All right, at this time, we're going to go ahead and get started with our JCIT meeting today. I want to welcome everyone that is here. We're here and thankful for the Texas Association of Counties for hosting us this morning. We have a number of people online. Casey, I'm going to ask you to identify them for the record.
Sure. Online, we've got Judge Ridgway, Roland Johnson, Judge Stiff, Dean Stanzioni, Dina Williamson, Doug Gowan, Ed Wells, Jamie from Tyler Tech, Jennifer Williams, Jessica Griffith, Judge Woolley, Laura Hinojosa, Patty Henry, Roland Johnson, and Sion Shilhab from CCA. Let me scroll down. And that's who we have online today.
Casey, I'm online as well. Thank you. This is Laura Hinojosa.
Hey, Laura. All right, thank you for joining us. And do you see Justice Boyd online?
I do not see Justice Boyd online.
All right. As many of you know, Justice Boyd is leaving the Supreme Court of Texas, and also, therefore, he is leaving our committee as our liaison to the Texas Supreme Court. They will be appointing another liaison. Unfortunately, we don't get much say in whoever that may be, so we await that. But we do want to recognize the incredible commitment that Justice Boyd had to JCIT and the work and effort he did as a Supreme Court Justice to assist us in moving forward with all our initiatives and getting things off the ground. So I want to express JCIT and all of our appreciation for all of his hard work, his patience, and his wonderful advice to us all along the way. Hopefully we'll be able to see him before his departure and relay this to him personally, but otherwise let the minutes reflect our appreciation of Justice Boyd. All right, so we also have minutes from our February 2025 meeting. I hope everybody has had an opportunity to review those. In particular, please look to make sure, if you were in attendance, that the minutes reflect your attendance, because we do take that, that's important to us, that the people who are on this committee participate in the committee. So do I hear a motion to approve the minutes?
Gotcha.
So moved.
Okay, so we have a move and a second. All in favor? Say aye.
Aye.
All right, so the minutes are approved. All right, at this time we're going to move with some of our committee updates, and we're going to start with our standard committee. I'm going to ask Bob, who is chair of that committee, to kind of walk through that with us.
Thanks, Jeff Simmons. The Standards Committee has been very active since our last meeting, and in order to expedite this and focus your attention on the major updates into what Casey sent out a couple of weeks ago for Standards version 10, is if you look at section 5, this is starting with roles.
Yeah, can we put that up, please?
Yeah.
There have been a number of updates and changes to this. First of all, it was pointed out to us in a couple of instances where the descriptions for judges was not exactly clear to those not in the system, and so we've made attempts to clean those up. We've added visiting judges as a separate item based on communication with the presiding judges. We have added an additional role, justice partners, which is an example would be probation officers, pretrial services officers, parole, those sorts of folks for whom our information is necessary for them to carry out their work. And
Bob,
yeah,
for that one, y'all have bondsmen on there, and they're really just like the general public, so it's going to take bondsmen off. You have it as a justice partner.
We can, if I don't make any changes you like.
Yeah, no, can you make that bigger? Because
Yeah, they don't-
for some reason I can't pull this up on pull them up on my iPad.
Tracy, during our meeting, I remember we all decided bondsmen were not going to be on there. I know we had the discussion, maybe that's what the confusion is, but yes, the committee had said bondsmen would not be on there.
Okay. And Bob, another,
And that's under Justice Partner?
yeah,
Yes.
4B. Sion had pointed out under 4A in the copy that there was a typo after roll 1A through 1B. It said judged with a D instead of judges with an S. And then Sion also pointed out that we should discuss and talk about 1B, that we need to remove the language about justice court judges because they're down in 1C. And then the question was,
The question was, you've got as the title district and statutory county judges, but in the description you are also talking about constitutional county courts. So that's a little confusing.
so should we add constitutional and statutory?
Yes.
County?
Just take out statutory.
Where are you?
And just say
One
county
B.
judges?
District and county judges.
Okay.
Okay, anything else?
Let me look at can I see that? Let me see.
Yeah.
It says who judges and designated court staff. Okay, district and county judges. All right, okay.
Okay. Any other recommended changes for the rules section?
Okay. Go down to-
I just have one more question. On your justice partners, it includes Office of the Attorney General. What if an OAG is sworn in to a district attorney's office? Then do they become attorney on the case?
So say that again, Sion.
Yeah.
If-
Okay, under justice partner, you've got Office of Attorney General staff.
Yes.
Well, if an OAG is sworn into the county to help the county with some case, they are actually an attorney on the case and not technically an OAG.
So she's saying they may move, does this anticipate them moving from Category 4B Justice Partner to Category 2 Attorney on the case?
So,
Yes.
It anticipates that they are what they are when they ask for the access.
Would they still make an entry of appearance to become an attorney in the case?
Could this refer to just not attorneys as well? Because it says OAG staff, it could be like paralegals.
Yes.
Right.
Well, and could we just say OAG non-attorney staff? And because then you would have, if you're an attorney and not on the case, then you're 4A licensed attorney. And if you are on the case, then you're further up as attorney on the case.
You don't have a catch-all. You get to your highest classification if you fit multiple ones.
I think they get the same access, whichever one they're in, right? They get all the cases and the documents that are
In-
marked,
Not marked sealed.
sealed.
go back over, let me look at that. Look at Justice Partner again.
Well, actually, they get a little bit more access. That's
Can we see the column? Yeah, the full column.
Okay, there you go.
Yeah. So over to the side is all cases and documents, but now I can't, because I don't have the document up. Then jurisdiction, not marked sealed.
The difference between justice partner and licensed attorney, though, right, is not charged fees or not, and then if you're an attorney on the case,
You're not charged.
Right.
Or are you charged?
No, if you're an attorney on the case, you're not charged.
right? But if you're a licensed attorney, you are.
You are.
So, yeah, so the difference between attorney on the case and justice partners
And can we ask on Justice Partners on 4B, it says that they're not, they're entitled to all cases that are not marked confidential, sealed, but confidential is not part of that.
Correct.
So if they're confidential, they're not even in there, correct?
No, they are.
They are? So just Office of Attorney General staff, whoever they might be, for whatever reason, gets to see whatever is in a case?
I think if it's marked confidential, they should not have access to it. There's
I mean,
reasons-
so they get to see all the basically the intellectual property cases that are going on that are in the
The way
courts?
this
or-
is written, that is true.
Why wouldn't you though? I mean,
Why would they? So I can just go in and pull up a case in something I'm not interested in.
document, that's why they would do it. To see it.
No, but if
It's not
they're
sealed.
designated confidential,
But
that's what I'm
just
saying.
somebody check the box, right? Isn't-
Right, but they don't necessarily seal people's trade secrets and their customer lists and stuff like that. You mark it confidential. You don't necessarily seal them in the case.
Yeah, we have to remember that doesn't mean it isn't a public record that you can't go to the courthouse and get it, right? Somebody marking it confidential, that's not a court determination of anything.
Right.
Yeah.
You get it at the courthouse.
Well, except up in Travis County, the local rules have marked like our CPS cases confidential and
Yeah.
restricted. And I don't know about I do know about the IT, but for us, it would be the partners, all of those people would have access to those cases, which I don't believe they should. So that's what I'm speaking from. That's my concern.
I have to go back to when we started with all this like confidential, like that you
Right.
could check things. And back then, as our rules attorney was talked about, the court was thinking of the appellate court websites, where
Right.
everything's posted. And there's no login required. And they weren't really thinking about, this type of system that you
Yeah.
have to have a username and login to get into. And there's a lot of confusion about what is confidential, what does that mean? And again, it is just somebody that just checked the box. It's not that a court determined that someone should see it,
No, ours is not.
or you shouldn't.
But they sometimes have protective orders. You know what I mean? They have court orders, right, that are like for Class 3 cases, and you have protective orders, and both parties have agreed, and the court has agreed in order that if you mark these confidential and whatever.
I guess where's that in the rules, though? This is a procedure.
I guess where it says you can do a pretrial order by the judge that basically says this is, the date your depots are, this is when all of this stuff is going to take place, and that documents, can be deemed confidential, and they provide the way that it's done.
Rule 76A, though, talks about what you have to do.
Which is sealed. Yeah, no, I totally agree. I'm just raising this because we were concerned before, or the court clerks were concerned because of the way their documents and this integration system, the way the documents were like confidential and what would come out in the integrated system and that sort of thing. So I'm just raising this because we've had discussions about it.
And I'm just...
Yeah, no, I appreciate, and I totally agree with you
What
that
does that mean? Where does that come
yeah,
from?
that
What's the authority for
it's
that?
just a practice that people have been doing.
So-
It's,
And we do identify elsewhere in the standards that sealed means sealed the way
Yeah.
we all know sealed being.
right.
And then confidential is whatever the clerk or the filer marks as confidential.
The filer will identify it, and then we just
do it.
We ingest it into our case management
Okay.
system. We mark it as confidential because that's what they have designated it as.
And then there's documents that are marked public, which is not confidential and not
Yes,
sealed.
we are marking cases confidential because of local rules. And
Yeah,
that's what-
there you go. That's the other wonderful thing. And I guess that's the local rule in Bear County, you know what I mean? And that's the problem with, let's just go on the internet and put in our own personal preference.
That's beyond my level, but I just have a problem with Justice Partners being able to have access to confidential. So that's all we're asking.
Yeah, this is a big problem. I'm seeing a lot of people
I totally
criticizing
agree.
the system because so many things are not available, and they're not available just
Right.
because people are checking a box.
I totally
that
agree
says,
with
"I don't
you.
want to see this."
So actually, there needs to be a definition of confidential.
We need to
Good luck.
There needs to be some authority.
I don't know that we can do that.
Yeah.
Yeah. John, if you recall, a few years ago, we spent 2 or 3 meetings trying to come up with that. And we would get to where we thought was consensus, but there would always be a yeah, but in our county.
Yeah.
And we can't do standards based on, well, I guess we could, but we so far have not done standards based on county preference.
But then what you're doing is making courts function 254 different ways. Well, actually, you have
Oh,
county.
I'm with you.
But-
Oh, I am absolutely with you. That's why that's why we've made a push for all these years for standards. But I don't know where the authority is or what the definition is of confidential.
It's
How
usually
they-
what the
how we
lawyer,
say
it's usually
standard.
what the lawyers decide,
Yeah, how
frankly.
does Tyler determine that?
So what happens on the back end is when you're integrated with research, say John's integrated with research, as part of his activity and integration in his case management system, here are document securities in your CMS. And then his team went through a mapping exercise to say, we have this one called sealed. On research, it should be sealed. And these should be labeled confidential. And these securities should be public. And then so whenever John makes a change in his CMS and it gets transmitted to research, it says, here's the document and this is public, or here's the document and it's sealed, or here's the document but it's confidential.
So is it both when an attorney marks it and also if somebody in the clerk's office marks it confidential?
Correct.
Yes.
And then the local practice from what John's saying is his clerks don't touch it, so that if an attorney says it's confidential, then they let it on through.
Yeah.
And I gathered that in Travis County, there's some other case types or
Yes.
document types. Is it the entire case type or is it document types that are marked confidential?
Generally, it's case types, it's the CPS cases that are marked confidential and restricted. Any other comment? Yeah, and occasional documents, but those
Regular.
are generally sealed, but,
And I don't
Okay.
offer this as a criticism of what you're doing.
No.
but It does
No,
sound
no.
like, we go through the matrix and we determine like
Right.
what cases and like, and I think this is, you're pointing out that then now counties can override that and they can do whatever they like in terms of.
I don't think they're supposed to, right? Their local rules are not supposed to go against basically rules of civil procedure, or I would assume if the Supreme Court has ordered these standards put in place, then you've got a Supreme Court order. So
That's
I'm
the
not
theory.
sure they should be doing it. The problem is enforcing
Exactly.
these rules when they're, they think they can do all this kind of stuff.
But, so for all the counties that have local rules, did OCA just adopt what was already considered local rules? Or because now, if you're doing local rules, you have to submit them to OCA to review.
No, you have to submit them to OCA, period. There is no review, there is no approval.
I thought that was.
We're not going to give you
No,
any
you log
ideas.
in
Just
and you hit
ignore this part
upload
of the
and then it's done.
conversation, John.
Yeah, that's some recent
yeah,
change.
OCA just posts, they're just required to post it, that's all.
We're just
Oh, it's,
John is a good friend of mine who at the time was a sitting judge, now retired, observed just how many court systems does one state need?
Yeah.
yeah, no, I just is amazing. And I've talked to Justice Boyd about this, and I think they absolutely need to go back and unfortunately we need to go back through and do what we did many years ago, which is look at all the rules. The state bar looked at all the rule committee, looked at all of the local rules and kind of got them all in place, and you kind of knew where they were, and the Supreme Court got updated and updated their thing.
Scan them all.
Exactly. And now,
The nice, well, I don't
who's
know.
keeping track of them? I don't know.
I was always under the
No
impression
one.
that
They're just up in
before
the
you-
cloud,
before you
hey,
can
whatever we
actually
want.
implement your local rules, they have to be reviewed and approved by.
That's because those
No,
are three
that's
Well,
the
and
way
the
it used
problem
to
is
be.
now they also are impacting the guide and file because that's how they just throw up, this is what you've got to tack on to your petition for divorce for all of your stuff, which is not in the guide and file that's been approved by the Texas Supreme Court. So it's kind of wreaking havoc, and it's probably something we need to address. But going back to this, I do have a question for attorneys on the case. So attorneys that have a case in district court, they are limited to everything that is available on that particular case, right?
Correct.
So tell me just so I can have a better understanding of why just somebody that is OAG staff can see everything in the whole system. I don't understand that. Why is the OAG staff doing that? I mean, I can understand why they would have access to everything where the OAG is a party or whatever, but I don't understand why they can just get on and look for divorces or whatever else is going on.
In Dallas, one of the things that we did when we were assigning rights, our access to our case management system, the public defenders, who's a part of Dallas County, believed that they should have full access because they're part of Dallas County. But we said, no, you're acting as a role as an attorney representing a defendant.
Right.
You should only have the access that a criminal defense attorney has.
Right.
You should not be treated special. You should have special rights just because you are an employee of the county.
A public defender.
I think that should apply to the attorney.
Well, I'm just wondering. I'm just curious as to why we would give them, or why they should have access to.
And Judge, to your point, if they are staff of the same firm of OAG, then they would technically have the same access as the attorney on the case. And so in this case, what we could do is just eliminate the and Office of Attorney General staff out of 4B, and then that way if it's their staff is in their firm, then their staff can see
Yeah, I
cases
mean, I
and
just.
documents of their cases.
Right.
What I'm trying to remember is who asked for that.
Yeah, that's what I mean,
I
there
don't
probably
remember.
is a reason for that, but I just don't know what it
Well,
is.
somebody on the committee asked for it.
Yeah.
Okay, well, no, and I don't think we're prepared to approve these today. I think probably there's a couple things that need to go back, and that's one of them, Bob, to the committee, just to see why is it that was in there and who asked for it, because I don't want to do anything that doesn't make sense, but I just.
How about we unplug it, and when the lights go off, whoever says, hey, I can't do this, and then we go back and address it.
What I would rather do is just remove OAG because,
Okay.
because the committee members
Or you can add it.
are all on it
Okay,
right now.
so we could.
nobody's speaking up
Okay, so
for
we
it.
could, and we could add them later if it proves to be an
That's
issue.
right.
But
Yeah.
we have a comment over on the.
Sorry, I'm with the Attorney General.
Perfect, help me.
I've been the agency's liaison
Yeah.
for e-filing since 2013, and I
Uh-huh.
do come and sit in these meetings.
Yeah,
since the
perfect.
beginning. I know I can't speak for all, but I'm the staff of the Attorney General's
Yeah, yeah.
legal assistants normally do a lot heavily of pulling the documents and things like that. We do have our prosecutors who then take the oath and become a prosecutor, which earlier we talked about. We also have our child support division, we have environmental, administrative law, but sometimes they go in and look at other cases to formulate cases for the Attorney General's office. So it may have been that they were wanting access to other cases, in the process of when we're gathering information for particular cases. But again, I, can get clarification. I'm happy somebody did put the OAG on there.
Yeah.
But we also know that we, don't want to override our privileges of having access, but particularly if an attorney is of record, your staff is going to be part of the firm.
Absolutely, we're in
Absolutely.
total agreement with that they get to see whatever the attorney does. I just don't understand why staff would be able to see a lot more than the attorney would be able to see.
You could have the same
So-
thing though with jail staff. We've got jail
Well,
staff in here.
that's what I don't understand either. I mean, why do they have more than an attorney? I mean, I don't understand this. Let's see. Why do they have such a wide breadth as a justice partner? Why are they not? Do we need to clarify? Like,
So,
Actually, I think when it comes to jail staff, they should be limited to whatever is available at their local jurisdiction, and
Yep.
not anything else.
right, and that's what
It's within their jurisdiction.
within their jurisdiction.
But even then, what's jail staff going in?
why are they going in to look at divorces and stuff? I mean, I don't-
Exactly. I mean, that is,
And yeah,
They will.
exactly. I mean,
Well, they can do that now. I mean, come on, folks, if they want to look at what's happening in divorce between Captain X and Deputy
Right.
Y, they can go find that out.
well, I
Probably
understand that.
before the case was filed.
But why are they getting more access than attorneys that are bound, you know, as officers of the court? I don't understand why jail staff is.
They're
That's too
officers of the
broad.
court.
We need to look at this justice partner category. What is that? Let's go back and just who are those? What are we trying to address there?
Probation, specifically probation department employees, not all, but some, which would be controlled at the local level.
Okay, and they're supposed to go look at what? What do they need access to?
When they're doing a pre-sentence investigation for a judge, they're going to want to see what other cases are out there, what other dispositions are out there, and particularly if it's divorce or something to do with kids.
Okay, and
Pretrial
so
services agency officers,
So-
and depending on which county you're in, they're doing much of the same work. Parole officers get into the same situation.
but do they not fall under the staff? Because it would only be in the cases in which or pertaining to a particular defendant in the criminal aspect, right?
It depends on which county you're in.
Really?
Yes. In some counties, pretrial services is operated under the probation department, but funded separately. In other counties, you have standalone pretrial services agencies that are set up under the commissioner's court.
Well, that answers probation staff and pretrial staff, but what about jail staff?
Jail staff is out, I think.
They have.
What are they looking at and what for?
And
I don't
it's-
remember us putting jail staff in there.
I remember it was another thing, but we can certainly pull it out.
Okay.
I mean, the intent was specifically probation, parole, pretrial. Those folks that are doing work and research on behalf of the court.
So
Can you think about maybe putting the, I don't know, this may be too broad, saying all cases,
I'm sorry, you can open the door.
hello?
Go ahead.
all cases as designated by the court? Is that too broad?
Who in the court's going to designate cases?
Okay.
Yeah.
Clerk's office?
Okay.
So here, okay. And, all right, so in pretrial, let's see, we're talking about probation staff and pretrial staff. Who are they? Who are you referring to as pretrial staff?
People that work for the pretrial services agencies.
Who are the, like who? Who are the pretrial service agencies?
The ones that review and give recommendations on bond, criminal cases.
Okay, so right now, the way that sentence is, your pretrial staff is referring to probation staff, right? Is that what you're referring to?
No, different.
But it's along the same lines, it's just in some counties it's split and it's not part of probation.
Yeah.
It's split. Yeah, so what's...
Okay, that broad category, though, if you're going to ask me, if we're talking about Bexar County, I don't know who you're talking about. I have no clue.
I understood.
Each judge has different things. I don't know what that pretrial staff is or who they are. I mean, that's way too broad if
You
you
get
ask me.
arrested, you get booked, and then you've got to be interviewed by someone who's going to be making the recommendations. Are you a good risk for a pretrial release? And then monitoring, there could be some conditions and monitoring those conditions. Those are kind of pretrial staff.
Yeah.
So what do they do now?
Oh, I don't know. That part, I don't know.
I'm just curious
Well,
about what they
let me
do,
just speak for
how that
Travis
works.
County.
Yeah, help me out.
We are able to designate it within our own
Yeah,
case management.
that's what I was
system.
wondering.
Yeah.
And Judge Ed Wells had raised his hand on.
Okay.
Go ahead, Ed, unmute and speak.
Thank you. I was just going to say to help clarify that, under the statute, typically pretrial services staff would be referred to staff of the personal bond office, and that might clarify it, because there are several counties where that's a separate department and does not fall under probation, but it's listed in the statute as a personal bond office.
So should it be pretrial staff of the personal bond office? Is that
Instead of
what?
pretrial staff.
Just staff of a personal bond office.
Okay.
Because if they're a part of probation, they're going to be included in probation staff anyway. But if it's separate, and so I wouldn't have pretrial staff, I'd just have staff of a personal bond office.
Because he says that where some counties may call it pretrial services, the statute, I'm not sure that's probably correct, but it says the statute refers to them as personal bond offices.
Yeah.
So we should use it.
I think we
correct.
should. That makes much more sense. Sorry.
What's that? Go ahead.
Casey, may I ask a technical question?
Yes.
Just back to what Blake was talking about a while ago on designating some information as confidential.
Mm-hmm.
We currently have an AI product that goes out and searches filings. Does the AI scrub data that it deems confidential, and what are the parameters?
It does not scrub data that it finds confidential. The way that technically works is today a filer, upon filing, can say, I want a program to go in and make suggestions on what I need to redact that is sensitive information.
So the user's the one using that, not
The user uses that, and then the filer does, and then on top of that, the system says, okay, this is what I think you need to redact, and they need to affirmatively go in.
They select. It's not that the state, that JCIT or whatever, has a product independently looking for it.
No, we don't have a mothership that looks at everything. Yet.
Yeah.
It could run, theoretically, it could run on research Texas.
Right.
And
Yeah.
that documents on research Texas automatically.
We would just need to define the parameters of what we scrub then.
Right. And we
Yes.
can pay for it.
And pay for it, yeah.
Thank you.
All right, so we've amended 4B then to say staff designated by the clerk that are justice partners of the jurisdiction, including probation staff and staff of a personal bond office. For now. And then, of course, we can,
Okay, go
nothing
back
is ever
up.
set in stone.
Let's go.
Back
Let's go
up.
back up the chart. Yeah, because unfortunately I can't pull this up.
This is Judge Ridgway. Can we go back to 1C where it mentions sitting judge, but it also could be a visiting judge? And they don't go through the regional judge that's covered for other courts.
That's right.
Oh, that is true.
And Judge Ridgway, is that maintained locally at the JP office on who's visiting and who's not?
Yeah, the sitting JPs approve annually those people they want to be visiting judges. And the visiting judges can say yes or no, I'll sit or I can't sit.
Right.
I would consider changing the word visiting to special, because other counties can have the county judge. The constitutional county judge can appoint a special judge in the JP, and that covers both instances.
Oh,
Good point.
thank you.
In categories 1A and 1B, when we have visiting judges, do they take on whatever role they have in that case?
No, they would take on 1D as a visiting judge, because in the appellate world, appellate visiting judges are also appointed by the presiding judges, correct? Yeah. So they would fall into 1D.
And so what about our business court judges? Our new business court judges, the appellate part is covered by the appellate courts. Are business court judges covered under district and county judges?
Not by this definition, but the reality is they act in
It's
a
the
lot
same.
like
They should. They should have the
They act
same.
like a district court.
I'm just saying, do you want to include
Yes.
business
Yes. I would say
courts?
yes.
I think we
Yeah.
need to do that, because
Yeah.
otherwise, not there.
So what's the difference between county courts and the county courts at law? That's all the same.
Probably the same. If you just say county
Their
courts,
jurisdiction is different, that's all, but county courts might.
but if you say county courts, will that cover it?
I would just leave it in, because it is something very distinct, actually.
Okay.
And don't even get me
Like-
started on a constitutional judge, a county judge who doesn't practice,
Right.
doesn't do any.
Welcome to Limestone County.
That'd be like if I ran for election for county judge and got it,
Handles all the juvenile.
even though I have no law degree.
Yep, yeah, handles the juvenile.
But if you're not having a need for it, I mean, there's room for abuse in a lot of this, and just hope they won't.
There is room for mistakes.
I have a question about a different set of users, just to make sure they would be included. What about like the state disciplinary committees or the board of law examiners for character and fitness investigations? Are they included under, I think the category was justice partners or something like that? Because there's not necessarily a case at issue. It's, they're doing investigative work on behalf of the bar or whatever. And do they need to be included in here or not?
What's their access now?
I have no idea. But
Yeah, I don't know. What's the bar, I mean, the local grievance?
No, they don't have access. They can call us, or they get on from Travis County, they can become an attorney under our attorney portal. But no, they don't have any special access.
Right, and they would, by definition, not be attorneys on the case that they were
Yeah.
looking to investigate.
So the most they have is the licensed attorney, so they have access to everything that wasn't confidential and sealed, and then they'd also be charged. So the real difference is, should they be charged or not?
As long as they were, the staff, in addition to the licensed attorneys, have that.
Okay, thank you.
Just try to come up with a standard.
Okay, thank you for that.
Anything else on rules?
We end up with a lot fewer justice partners than we started with.
I'm just going to say, just for the record,
I have a question.
I still would prefer to have confidential in it for the justice partners, but I know I've said that multiple times. I just want to say it one more time.
Okay. On visiting judges, basically they get all cases and documents statewide not marked sealed, and documents in these cases are not charged fees. So what if they are assigned a case that has sealed documents?
They will need to go to the clerk, because the issue is that the way, when you get into the mechanics of how would you implement this, we would take the visiting judge list the PJs give
Yeah.
OCA
Yeah.
and give access. But the problem is that you can have a visiting judge be like, I need Judge Simmons to come and hear this particular individual case, or it could be,
Yeah.
I need Judge Simmons
It's
to
matter, yeah.
for this 3-week period when the sitting judge is out. And when you do those
presiding.
time-based things, we have no idea what cases are coming in front of you. And so I think the committee discussed, well, in those events, if you're a visiting judge and you need to see something sealed, then just go to the local clerk and get it that way.
Or if you think it's going to be an issue, go to the presiding judge that appoints you and have it put in the appointment order.
Why wouldn't you just, I just, don't know why you wouldn't automatically have access to a sealed matter if you have been assigned to that particular case.
Because research doesn't have a notion of this judge is assigned to this case. It just knows this
I
case
see what
is
you're
in
saying. So in
county.
terms of implementing on the matrix what you're
Yeah,
going to do,
you
I
don't-
see what you're saying.
Well, and then it came out in discussion committee, there's lots of different local practices
Oh, yeah.
and accommodations.
Local rules.
Yeah, that we may or may not know about. Yeah.
Yeah.
That's why there are accommodations.
Yes.
Either the judge of the court or the presiding judge work out with the judge who's been assigned or is going to be assigned.
Okay. All right. I understand now. Thank you.
One more time, anything else? And Belva, we won't let confidential drop. We just don't know where to get it there.
Okay. Well, I can open that too.
And Bob, did y'all make a note or include the, like I said, the state bar disciplinary or?
Yeah, what do we want to do?
Where are
Or
we going to put that group? Obviously, the attorney, they'd be at the direction of an attorney presumably, so they would be licensed attorneys, but the staff would also need to get access. But they wouldn't be attorneys on the case. I'm investigating a grievance, let's say, right? Or, the grievance about something, you want to have access to this, but you wouldn't be an attorney on the case, you'd just be licensed attorney.
Yeah, do you have the same issue with the Commission on Judicial Conduct?
Right.
Staff?
All those, I mean, and it could be a number of different organizations, but I'm just bringing that up since I saw the justice partner category.
Do we know what they currently have access to?
Yeah.
Right now, if
Vela says, at least for Travis County, they just call the clerk's office and get the grievance panels and the further investigations.
Well, not the grievance panel.
Well, not the.
But the attorneys have access to our attorney portal. So, and that's
So
all.
nothing special.
no, they don't get anything special right now.
right now, SCJC
They
and
get just as if they were an attorney, not on the case, just in
Right,
general.
licensed attorney is
Right.
what
licensed attorney, if they're an attorney, and if not, it's just an investigator that's not an attorney, then you're a registered user.
So, Bob, I do have a question. Under 1.3, under definitions, where did these definitions come from? And can we add confidential, a definition for confidential under 1.3?
But we're not using confidential in the matrix, right?
No.
That word. So why would we define
It's
it?
5.2.
Where is it?
We're using it not in the matrix, but in
Right.
the definition of what your permissions are for things.
Okay, so go to 5.2, because is that where
5.2 just tells you
Right.
that it's the three things that you can pick from. Hold on, I'll get to it. There it was.
yeah, document security level, that one? Public, confidential, and
Yeah.
sealed.
And it doesn't give a definition, it just says what confidential, it's a restatement of what's above.
And that was to handle when you have a document marked confidential.
Of who can see it.
So,
And that's as far as
That's as far into
that
definition as we
committee
got
got
into. Yeah.
at that time. And after this discussion, you can see why.
so right now, remind me how this works. Okay, so attorneys can redact or not redact.
Up to
right?
them.
They can designate something as confidential or not
They-
confidential, or did
They
that
can
go?
designate that this document has sensitive data or not.
Correct, that's what I meant.
Yep.
Sensitive data or not.
Yep.
And if it has sensitive data,
Uh-huh.
then just general users can't see it, and only the attorney in the case can see it?
Correct.
Okay. All right. So confidential to me is I'm not sure if that's the correct, either it's sensitive data or it's not. That's what our rubric is, right? Is sensitive data. I mean, that's how it affects the system.
I mean, that's the source of the confidential.
Yeah.
It's the sensitive data.
Yeah, exactly. I'm just trying to figure that out. This is a more complicated thing having to do with confidential and all of that.
Yeah.
What are we doing there? Is it the sensitive data
Well, I guess
designation or what?
the question is, because on the research side, the filer can say this document has
Yeah,
sensitive data. Then when it goes into the case management
Right.
system, it's a local practice. In John's case, his people leave that alone, and then that translates into their case management as confidential.
Oh boy.
And then from there, it goes to research and gets translated again and stays confidential.
You can redact confidential information though without restricting access to the entire document. I mean, we make attorneys do that all the time.
Sure, and this.
And that's what the system,
And-
now offers, right?
Well, only at the filer, but then Mike makes the same point that you had made earlier of, if I have a document with sensitive data in it, and I redact it and put a bunch of black boxes on it,
Then it's no longer
then
sensitive data.
there's no longer sensitive data in it, and it should be public.
It should be public with the redactions.
If it's going to be sealed, then it's got to go to the
To
sealed.
research.
Exactly, which was the whole public policy of sealing.
Part of my
Okay.
concern about this
This is-
nomenclature too is that I think
What if I give
there's
you
sometimes
copies of
confusion.
CMA?
Exactly.
Some clerk's offices where they see confidential and they think that means that you can't even get it in the courthouse.
Right, yeah.
Don't let people have access to it.
Well, because you have a local pretrial order things that have that in there, so I can see that. I think we need to take up this whole confidential and process thing, particularly as we go into integration, in terms of to get real life, what are clerks doing, find out what the different ways of that they're dealing with this, to see that we don't overly restrict documents that should be accessible.
Yeah, I think it's an interesting catch-22 for some attorneys because I think on the one hand, they'd love to be able to see everything, but on the other hand, they'd love to mark everything that they file as containing.
They do.
They want to be able to see everybody else's stuff.
But I think Justice Simmons, there has to be an exercise for clerks, for the clerks to provide you, for us to provide you information as what we're actually seeing. There's a confidential document in a case in my case management system, and I just say, okay, just describe what's confidential in those cases, because there's confidential, there's sensitive, and then there's personal identifying information, PII. And so what is all of this?
And how is it all treated? Yeah.
And so, like on the research side, John may have in his sensitive data, confidential, and PII, but then to research, there's only three things: public, confidential, and sealed. So John has to say PII, that means confidential. Confidential, that means confidential. Sensitive data, that means confidential. Because it's multiple systems talking.
Complicating the two terms because, you can file something and redact it, and not all of it is.
Then it's not it's not, because that's the whole point of redacting, is that it's now available for public view.
And if something were confidential, like a trade secret or something like that, like the recipe to Coke or something, you would file that under seal.
You would.
What I've learned from this exercise, I'm kind of following more toward what Blake started with, and the idea that, what is confidential is really everything you can get at the courthouse anyway. And my example I use is that I have been deciding these things that we've just done when we talked about bondsmen or we talked about certain jail staff. About, my God, why should they? And I've heard you say, why do these people need to be looking at every case, everything? And for me, my standard's been the opportunity for abuse. But when I look at, say, even attorneys on the case, you look at their staff is included, your paralegal staff, anyone authorized by the firm.
Right.
They get to see everything statewide. So if there's going to be, I come from a prosecutor where we have sieges. And that criminal justice information is the most important thing. It's a crime for the wrong people to look at and disseminate it. but that's audited. Every year they come to my office and there were cases where saying, why did this attorney look up Rebecca's name?
Yeah.
And we'd have to justify why we looked at that. There's no accounting for anything that can be for everything looked at. So if it's abused, it's gonna happen. And so for me, I'm no longer really, it's not on my list of can this be abused. It can be abused. And so I would argue that, now going back, jail staff probably has a better reason to look at a lot of these things than just any old person authorized by some private law firm to go searching for things.
Well, but then, you know what? You can sue that lawyer. I mean, there's going to be somebody accountable if their staff is out of control.
It's not a
and there's
crime
some sort
to
of
look
thing.
at. See, the idea
No,
is
for
we
money.
got a nosy, what we really saw in the criminal side is these nosy people. It's a family member that heard a rumor about some ex-husband, the ex-husband deal, and they get online and they pull the criminal history that they got arrested and all these kind of things, and then they share it. That is a crime.
Right.
But on this, same kind of thing happening, but not looking up criminal information, just looking up the divorce, and those things that aren't sealed. It's not a crime to do it. They might get fired by the firm, but it's some kind of, and if they ever found out about it, there's no auditing of any of this kind of. So I guess all I'm saying with SRAN is that I've given up really looking at using it as a standard about whether it's abuse or not. Is who's got a better reason to look at, a justifiable reason to look at this information.
Yeah, no, I think though what concerns me is that we are, not by virtue of the matrix, but by virtue of the process, through designating things as, restricted and whatever, all these things are creating kind of this separate thing that is not really statutorily based or whatever, and so it's going to impact our matrix. So I think we need to take a look at the whole thing about how, because technically the public is entitled to see documents.
That's exactly.
You know what? And there's a process. If you don't want them to see documents, you go get it sealed, or the court will seal it, whatever, okay? And then we took care of confidentiality and divorce and children and guardianships by basically dealing with the matrix. And there's certain whole levels that just are completely out of there, that are not visible, that we've taken care of already. So I think we need to clean up the disparate sort of
I think the real standard now is just should they pay or not? No, really. Should they be charged or not? Do they have a justifiable reason to see this? Should the AG's people see this? And really, I think they should. After I come around this, the question is, should they be charged? Depending on what category they're in.
There was a provision in the statute where we cannot, another government agency cannot be charged. So I think in that case they couldn't
For research?
be charged.
Maybe it's in here.
Yeah.
So then if I'm the defense, how come I don't, well, I guess I do get it because I'm an attorney on the case. But if I'm a general defense and want to go look and you're not charging the opposing counsel, and you're charging me.
Well, and that goes back to the role, because now you talk about another government agency.
I guess I was wondering, because when you look at Justice Partner, every one of those is a government, except for Bondsman, we took them out first, is a government, someone affiliated with a government body. So when we sit there and say documents in these cases are not charged fees, I thought there was a reason for that, but it's statutory. They're not charging anything.
So do you want to take that out? Or are we going to leave it in?
I guess it just
It just reinforces that, so everybody knows, including clerks. So,
And I think, let me say this, I think what we have to make sure of is that our technology standards are consistent with what somebody would encounter if they physically went to the courthouse to pull up those records.
Right.
Because if there's a different way to get if I can show up at the clerk's office and say, may I look at this file, and they're not charging me to look at the file, or they're giving me access to the file by a way that they're doing it. And then there's a different process if I'm doing through the electronic process, then we're not really providing what we would be doing ordinarily.
I agree completely with the exception of the mass, what do we call them, the information, the data gatherers type of a thing. They can't get all of that showing up to the courthouse, but they can get it with the press of a button. But we've got, I know that we've got to research ways to limit.
And I don't know that legally we're required to let them, take it in mass. I mean, that's a convenience for them, not something that's constitutionally required.
And that's what those counties where you can go to the courthouse and see and get paper. If you come from Dallas County, you're going to be directed to.
Well, if we take, and Justice, I agree with you. It would be much simpler if we just said in the matrix, if you can get it at the courthouse window, you can get it here through research. And that will mean a significant change to the matrix.
There's an e-filing rule though that says if it's marked data sensitive, you are not.
No, that's what I'm saying. That's
Exactly. There's rules for the internet.
Right.
That don't apply to over the counter.
Right.
So I'm sorry, I don't believe that it's that cut and dry.
I don't either. And people don't know today what over the counter even means for most clerks and people. I mean, it's.
And young lawyers don't know what over the counter means.
Right.
So,
If they've been practicing 10 years or less, they have no clue.
Yep.
I think
Okay, go.
that is exactly
What?
the problem, and I think the solution is that needs to be changed. Because this was the first iteration of this before we really knew that we were going to be able to do something like this, to have a statewide, truly a statewide system.
Yeah.
We just invented it from whole cloth, and it doesn't work.
Yeah.
And I think it needs to be changed. I
Okay.
think we need to tell the Supreme Court, we need to relook at this. Like this idea of letting attorneys mark things and essentially suppress them from the system is not a good idea. It doesn't work. It's causing lots of complaints about this statewide system because people feel like it's not good because they can't find what they're looking for. And
Right.
the big reason they can't find what they're looking for is that we're letting the foxes run the hen house.
But the fact that we're not letting them look at other cases as attorneys is the primary means to block them from access, not the marking of sensitive data. If they're on the case, they likely have the document already.
And before we make this change and open it up to all attorneys, we have to make sure we lock down the way you sign up as an attorney, since it's not locked down right now. We have to make sure that if they say they're an attorney, they are an attorney, which there's no.
Do they not have to put in the bar number?
You just put in your bar number, but that's it. But if I know your bar number and you haven't claimed your account, then I can.
Got it.
Or if the attorney is,
Crazy.
well, if the attorney, I don't want to say deceased, but if the attorney is on bad conduct or whatever it's called.
I mean, the disciplinary
Action,
suspended
right?
for.
You can still sign up for it, right? And still get the access.
Well, there's if you're suspended, that doesn't bar you from looking at case info. It just bars you from practicing.
Well, but should it bar you from e-filing?
It should be.
Or
That's
seeing
considered
confidential
practice.
cases and getting free copy.
Well, it can't
right?
bar you from e-filing.
But if you're a lawyer and your license is suspended, that means you shouldn't be.
Well, I mean, but what if you have a case for your own self? I mean, you know what I mean? I'm just saying.
Yeah.
You're per se,
Well, you're still licensed attorney, your license is just suspended. So I don't know of our definition of licensed attorney.
right? It should say
In
it.
good standing.
You can say it,
Yeah.
correct.
Not deceased either.
Correct.
A living attorney.
I don't know that the clerk's offices enforce that though. If I were physically to show up with a document in hand and want to file it and stuck a bar number on it, I don't know if the clerk's office
We
verify.
They would.
They wouldn't take it.
We have no way to.
They
You're
would.
going to accept it because you're the clerk.
You can e-file if you're a paralegal or.
Yeah. It's just the access to research Texas
Right.
Yeah.
is the real
Yeah.
concern.
But all these rules about the sensitive data, because we're identity theft.
Right.
And,
Which there's one.
and this has gotten pretty complicated.
This has gotten somewhat complicated.
Yeah.
Let's just see, look at a couple of documents that's marked confidential and see what information is they're saying is confidential. And does it comply?
What I would tell you, and this is, and I don't mean to interrupt, John, I'm so sorry. My frustration is the family law documents that are filed in family law cases, regardless if they're confidential or not, the forms in the family law form book comes with confidential, just automatically on the document that they print out.
That's right.
It's whether it has anything to
Order setting hearing.
Confidential.
Yeah, so it's already pre-stamped on the form, and so it's very. We need to take a really good look at the self-identification of a lot of this stuff. I mean, we're acting like nobody's self-identifying when we look at all this stuff, and they are. And so wholesale markings of confidential are going into documents that aren't restricted.
Yeah, we thought of other solutions like some kind of pop-up to scare you away from marking everything.
Right.
I don't know.
I think
that ever got.
I don't think that's been ever finalized.
Yeah, you know.
I think it just doesn't work. I mean, it'd be interesting to me too. We did a lot of stats about return for correction.
Right.
And I think we should probably get some information about what's going on in the system in terms of how many documents are being marked confidential and what case types are they. And I think we will see that we're going to find that there are users out there that are just routinely marking everything.
Everything because it's belt and suspenders.
Regardless of what case type it is.
Yeah.
And you're absolutely right, because they don't know they're going to err on the side of caution. And so let's just do everything.
Yeah.
And because we don't want to be wrong. So.
Yeah.
The concern is, though, that if you have a process that allows that to occur, you have the equivalent of a sealing order without ever having a sealing order, because the public still can get access to it, and that was the purpose of having it sealed. So you don't have any of the due process requirements, you don't have any of the public hearings.
Or any of the public notification.
You just simply click a button.
Well, and 76A says that you have to prove that there's not a less restrictive means like redaction. So it's kind of like just a broad stroke to make everything confidential.
So should we just, so that we don't continue to beat this horse, should we just have a working session?
I think there needs to be a working session, one more session on all of this to address it, because I would hate to put this in place and then us have to go back and go, hey, we found a simpler, easier way to manage this.
Yeah.
I think it's impacted by what we decide or what our next steps are that we think is best. After gathering, we need to gather some information from the clerks and see how they handle all this anyway. And kind of get together. And Bob, you've done a tremendous job as always on your committee, and they are just workhorses. And so I'm going to ask them to work some more. I think we need to really look at this a lot closer, because it's kind of, we've gotten kind of what we asked for. We got the research going, we've got all of this, but it's not fulsome because everybody's marking their stuff confidential and isn't even coming in the system. So we don't even need all this, basically, hardly, because it's not there in the first place, right?
So
now, even with the integrated stuff, it's not there in the first place, because if you have marked that, it's just marked,
Or if you're integrated, which now more than, and Evan will show us, it's 30+% of the clerk's office, but if you looked at it by statewide population, we're well over 80% in population.
Right.
It's coming from whatever the local CMS has. So we're getting into the thing of telling the clerks, hey clerks, this is when you should be marking things confidential. Or, hey, we're not going to care if it's sealed, then we're not going to show it. But even if you mark it confidential, we don't care, it's going out unless it's not to the public registered user that JCIT says. But I mean, that would have to go out to the clerks, because I'm pretty sure that we would be getting an earful when...
Well, they're probably going to be sending a bunch of stuff back.
Well, the judges, I agree with that.
I mean, obviously, though, I think, to the point about having, I'm sorry, what did you say, it was CPS cases? CPS cases that are just by local rule, they're confidential.
But are the...
I take it, does that mean that if I came in your office, could I see those?
No, you have to show an ID, you have to prove that you're an attorney or a party to the case.
But if I'm an attorney, I can come in and see it?
Oh, on the case.
Oh, on the case.
On the case.
On the case. And nobody else can see that?
Okay, I see what you're saying.
So, how's that, as a taxpayer, how's that public access to the courts?
Well,
or public courts? Can I, if you're having a CPS docket live, can I go sit in the gallery?
It's up to the judge.
As a citizen?
Absolutely.
It's up to the judge.
Oh, it's up to the judge.
It's up to the judge.
I didn't mean to take us
in person.
in that direction.
So a judge could be like, no, you can't sit
See what you
in.
did, Blake?
It's up to the judge. is what
Can
I'm
I
saying.
appeal that to the Court of Appeals?
This was not the direction I was going with that. Where I was going with that comment was more to the, we're going to decide what's confidential or not, and you said essentially that we would be forcing that out onto the clerks.
Yeah.
The problem, though, is that the clerks have taken the direction from the judges who have passed a local rule to tell them what to do.
Exactly.
There you go. You can't do that. You're going to have that conversation about some of these things. And I don't think that it would be very impolitic of us to just tell all these local judges to go pound sand. We don't care what they decided with their local rules, which the Supreme Court has said they can pass, right? So,
yeah, if they're not in violation of anything else, and they all are. I mean, you know what I mean? They're in violation of standing. I mean,
I hear what you're saying.
You know,
the point is you have to have the conversation with them about it. We can't just say, "Hey, we're going to make this change," and the Supreme Court approve it, and then you've got no choice about what you're doing. I mean, the court's going to have to know about this issue, right? That there are local rules out there that are changing.
Yeah, no. We have to look at all the local rules. We have to be able to take it to the Supreme Court. And my recommendation is you cannot let, with no approval process, have these local rules come in. I mean, it just because it creates havoc. It's lawyers, yeah, it's nice, it's convenient. I can go see that you've got these weird local orders, but I mean, I would hope the Supreme Court would do some, and I don't care if it's with OCA to make sure that, or with whoever wants to approve it, but I think there has to be some kind of approval of these local rules.
There used to be an approval process. I think that was let go during COVID. And the problem is now we have repeated launching of new local rules in Bexar County. The last iteration was 28 pages long, and that was the second in, I think, a year.
And so it's more like, what are your preferences? So they're doing preferences instead of local rules.
I'll say that in practice, I think that it varies tremendously from court to court, venue to venue.
Yep.
What gets designated as confidential, like everybody's been saying, I see that all the time in practice, and it does circumvent 76A and the mechanism to court and stuff. I think unless there's some kind of a sanction process, some penalty for doing this, I don't think that it's going to be very difficult to get either practitioners or courts to change. And I'm not here wanting to come heavy on anybody, especially without any kind of long warning. But I mean, I would say unless there's some kind of a, hey, you shouldn't be marking stuff confidential and there's a consequence.
We've discussed this in conjunction with the wrongful rejection of e-filings in years past. And without having a sanction against the worst of the two, which I think is the wrongful rejection, then I would hesitate to say, okay, let's carve out a sanction for overmarking, although I do admit it is a problem.
Yeah, I think the solution
Unless you want to have sanctions against clerks, which I don't think anybody really wants.
Right. Yeah, no, the idea would be more that the attorney doesn't have the option to necessarily mark things confidential. They can say that it contains certain information, and our redaction system takes that out, and they can approve or, unapprove that.
Yeah, it's almost like
Or-
we need to, Supreme Court, somebody needs to refine what is PII.
Yeah.
And it's either in as PII, and those are things that are marked, or it's out, and then if you want to go do something else, you go file a motion for seal and let the court deal with it on a case-by-case basis.
The option of having a redaction mechanism automatically, we raised about a year ago, and Justice Boyd re-raised it in a subsequent meeting. And so the option of having a flag pop up saying it looks like there is no sensitive information in this document, or there is sensitive information in this document, with a warning, was brought up, and I don't know that I don't believe it was implemented by Tyler.
Because
Yeah,
it was never
other
approved.
solutions, but I think this solution doesn't work. Letting attorneys just mark things
Confidential,
just
just-
controls.
Yeah.
It doesn't work.
And relatedly, I guess that some litigant could challenge the local rule that's in violation of this. That's the
Yeah.
other way to, as far as, over designating per local rule, that's the only way I can see that it would be addressed.
We're not in the vacuum. Is there anyone that knows what other states comparably do?
I was wondering the same thing. Does anybody else let attorneys do this? I doubt it. I doubt that that's how it works, but I don't know. Maybe.
I could find out.
Yeah. I'm pretty sure Pacer doesn't work that way.
Pacer doesn't work that way.
Well, that's true. They've got a lot of other stuff though, that we were talking about, trademark.
They have all the IP stuff and everything else, yeah. They'll seal.
And is that by,
They ought to be approached.
do we know the sealing on Pacer, is that by judge order? I would assume it is.
Sealing on cases in federal court?
Pacer system is the sealing of those things that done by order.
Correct. No, yeah, you have to get an order, and a lot of people attach it, and just because they say it's confidential, it's attached, it's in there on Pacer. And so then you have to wobbly scramble to try and get it back out, because it goes out unless there has been an order that has sealed it, and more or less sealed it in Pacer.
Yep. I think that's right. I think you
Yeah.
physically still take it to the judge
Mhm.
to request the seal,
Yeah.
and then the order signed.
Yeah.
And it's filed.
Yep. Yeah. Okay, so let's talk for a minute about next steps. Okay, so in view of our discussion so far, does that really affect these different roles that we're looking at right now? And that's all we're looking, that piece is all we need to look at. Just let's take a look at that. That's kind of what we've been discussing. Does that affect our definitions of these roles and what they can and cannot see?
What's a clerk administrator?
That's for some offices where the clerk, you don't allow all of your staff to see sealed documents. So the clerk administrator would see sealed, but just the plain clerk role would not. And we have that, because we have over 500 clerks. So we don't allow just everybody to see a sealed document. Same here.
Okay, go back to that one. Any clerk, where we were looking, where we talked about clerk administrator.
Only supervisors and management team, basically.
I say, well, if you're not part of my court staff, you don't even have access.
We have energy clerks and other people that do have access. Energy clerks. and
So
other
under
people.
3B,
Mm-hmm.
okay, any staff of the clerk administrator that have not, and that's just the definition of clerk?
Because 3A is clerk administrator.
Right.
Okay, and the clerk administrator, is that the elected official, the district
Yeah.
clerk?
It's anybody they designate.
They
It's a
designate.
deputy clerk.
Do they have to be called a clerk administrator?
Yes,
Right, for
'cause-
that role.
for that role.
You're either a clerk or a clerk administrator.
Okay.
You pick which.
But if I was in the district clerk's office of a small place, do I have somebody that is,
You just pick.
The elected
clerk
district
administrator.
clerk would be the clerk
yeah,
administrator
that's what I'm wondering.
to start, but
Yeah.
then, let's say you're in a small office and you have three other deputies, and you're like, I want them to have the same exact access as I do, then you as the elected clerk designate them all in 3A as clerk
And you
administrator.
designate them in the system?
Yes.
Or, okay, as clerk administrator, okay.
But in
And then,
Tracy's case, where you've got 500 plus clerks, their elected clerk says, I want this small group to be my administrators, and they can
Yes.
see everything in
Okay.
my jurisdiction regardless of security. And then, but the other 450 of them,
okay,
I just want them to be listed as clerks.
yeah, just look at clerk, okay. So, okay, staff of the clerk administrator, okay, and the small things that have not been given access to manage security for their jurisdiction. What does that mean? Who
As
accesses?
a clerk administrator, you can give access to the system.
Okay, so the system has some sort of process called managed security or
Yes.
Yeah. Oh, yeah.
security, and so it has, in there, so they would know what that means.
Yes.
Okay,
So 3B is a clerk employee who doesn't fall under 3A.
Correct.
okay.
And so their restriction is they're restricted to their jurisdiction, and they can't see documents that are sealed.
Okay, so now we've populated with many more roles, okay? How does that affect the rest of the matrix?
It doesn't, because the rest of the matrix is all about registered users of Role 5.
Okay, all right.
And we actually added 2 roles, the clerk administrator and justice partner.
Okay.
Everybody else is
Already
already was
there, right?
Was already
Yeah.
there.
And-
Right.
And we cleaned up those definitions.
And
Okay.
the other big change is this is now in a chart form, so you can read,
Yeah.
here's what it is, and
Right.
here's what
Okay,
permission
now
they
that's why
have,
it's-
rather than going through
the
multiple
different
sections and trying to piece
Right.
it together.
So, okay, so we have these, and that is separate and apart. I'm just trying to think of any impact on our future examination of the confidential and the designation of contains sensitive information questions that are
I
out
think
there.
this is separate from it, because I think, in my mind, the direction to the Standards Committee is go back and investigate what it means to have something confidential and suggest options of things that need to be done, separate from what the roles are. Because, I mean, if it comes back and says the recommendation is don't allow confidential as an option, well, then we just remove it out of here, and then that's not going to change the roles of what the roles are. It may change what you can see, because then we need to talk about public
It'll expand the
concealment.
contract, but
Right.
it
Okay.
won't change.
It won't
Okay.
change. The roles will still be the same.
Okay,
Worst case, some of them may be redundant, but that doesn't mean we've got to go back and redo the.
Correct. Correct.
yeah, yeah. Okay, so just in terms of these roles and the revisions that were made to the roles, then do I hear a motion about what we want to do? Or any further discussion on this, on these particular roles?
Yeah, Bob wanted to focus on these changes. Everything else was, all the other changes were additions.
Well, we have one
We haven't
more.
talked about them. Okay, go ahead.
We have one more quickly that comes from previous discussions that we've had over the last year. You recall there's been a good bit of conversation about restyle. What does it mean? What are alternatives for that term? And we are suggesting that it become protected. So in a juvenile case, it'd be protected versus protected.
Now what? Okay, help me understand. Go ahead. Where are we at restyle?
We're down here.
Restyle was the original designation in the matrix to shield minors.
Oh, I see,
names.
restyle. Okay, all right. Okay, now I understand. Now I remember. Okay, now,
So,
yeah. Okay,
read that
I
column that
remember,
says
yes.
it would say
Okay.
protected.
Yeah.
as opposed to restyle.
Right.
Gets them
Protected style. It's never there.
Right.
So that's the information that
Nothing there changes
appears
that.
in the database for purposes of
Yeah.
searching? I'm trying to figure out where that information
this is
shows up
research.
as identified as, research text as
Yeah.
protected.
Yeah.
Okay.
Yeah.
Yeah, no, that's, I
That's
actually,
fine.
I remember actually being in favor of that, and asking you to do that, so. Never mind. Yes, I totally agree.
Don't confuse me.
Yeah,
What the hell?
I was like, oh, right. Okay.
Anyway, the other changes that are in here are the typical things that we get during a period. We need another special service. Here's the statutory reference. We need a case filing type that's not here. We've had a couple of those. And I think that's all the other changes.
The only other
But
thing-
what else, we need to show everybody so that we know. If we're voting on all the other changes, can you scroll up about the other changes that we have? Because
Do you know for sure they're going to program the delay on our family cases? 'Cause
Yeah.
right now, everything's delayed, and I have to make sure it gets delayed for Harris County.
Yes.
So Bob, on the restyle, so it would say in a matter of the marriage of husband versus wife, whatever their names are, and then it'll say in the interest of protected.
Mhm.
I think it's going to just say.
As opposed to what
It'll
we're
say
saying now is
protected.
restyle.
it says
versus
restyle, and to me that is not
Okay.
Yeah, and it's
a
now
term
not,
of art or
it's now not restyle, it's protected
Yeah.
style.
yeah.
And so any case that's marked to the public. So if you are the attorney on the case, it's going to show up as in the matter of name of whatever it is. But if it's just me, Joe Public, it's going to say protected versus protected because there's the name of the kid in the case.
If I'm a member of the press and I want to do a story on a divorce,
Do you
how
know-
do I do a search?
Do you know the case number?
But the divorce,
Say I don't. Let's say I know it
the
involves
name
Mayor
of two
Smith.
adults is not redacted.
I know the parties.
For divorce,
You could search by the party, and it would show up as this is
Yeah.
a party, the mayor's party to the case, but the style is protected versus protected.
for a divorce, no, it's not.
If you're a member of the public, and it says in the interest of the kids.
Oh, the kid's name is protected, but
Yeah, the parties themselves are
That's
not.
why I was asking.
Yeah.
Parties' names can still show.
Kids' names are, we use initials most of the time. The
Yeah.
Attorney General, however, uses full children's names and dates of birth. So the protected would ostensibly pop up in those cases, perhaps.
but not to
Right.
protect the parent's name, just in the interest of, and then the protected would
Correct.
be the child's name.
Right, but if the whole case was Kennedy versus Kennedy in the interest of Max and Drew Kennedy, the kids' names are there, so it would just say protected versus protected for the style. You would still be able to search on the name to get the party or their attorney and find it another way, but just
This
not.
reminds me that a few years ago, the Fort Worth Star-Telegram called me because they had Tarrant County apparently a widespread practice of attorneys using just initials
Right.
and their names, so
Yep.
that you couldn't effectively find divorce cases
Yep.
there in Tarrant County.
Yep. For Lubbock County, was a period of time people would do that too. They just finally started just saying, we're going to reject.
Well, you can't get a judgment. You can't get a judgment just on initials. It just, or a decree.
So other changes that occurred, that the committee acted on, the definition of delay,
Where was that one?
it's down here.
I
somewhere.
don't know if I like that.
You were in the meetings, Tracy.
I don't remember us talking about that. Because I know I provided the statute, but I don't
Yeah.
remember us saying that.
You
it's
did.
just going to be first.
We talked about delay is the delay is based on the date the case is filed, because there was a question on, well, if we're delaying by 31 days for Harris County, then if I have my case filed today, then 31 days passes, and now my case is on research, and then I file a motion after that 31 days, then now does the clock reset and that case is now hidden for another 31 days or not? And the answer that the committee said is no, it's based on the date the case was filed, not when the last document was filed.
Oh,
So that's clarified here in the definition of delay, including
yeah.
including the statute. There was,
That only applies to Harris County because of the population bracket.
so, yeah, we did, because there's your site.
It's saying that only in family cases, this is only in the first one. Meaning they're going to be
Yeah.
open in other.
Yes,
And I don't remember that.
we did. We did. I remember having that. Okay, so then the other thing was splitting management trusts to adult and minor.
Can we talk about delay? I don't understand the last sentence. In family cases, the delay only applies to counties whose population exceeds 3.4 million.
Right, because right now the only place that a delay occurs is in family cases. And in Family Code 6.411, there's a thing that says in counties with a population of over 3.4 million, these cases will not be shown until after the 30th day they were filed.
Thanks, Texas legislature.
Exactly.
And there's a column for delay and whether it's you get delays or not, and so it's just in family.
Great, thanks.
Yeah. There is a piece that splits in probate. Currently, there was just management trusts, and so it splits it to management trust for adults and management trust for minors. For minors.
Case types.
Yeah.
Yeah. I'm sorry. This mouse is very sensitive.
Okay.
That's
It's
it.
Gummit. I know. To use the stupid arrow. Okay. So we have management trust now split to where we'll show adults,
I see.
but not minors. There was another one about adding temporary guardianships that we didn't have before.
Okay.
Talking with the former probate clerk on OCA staff and then our stats person, they said, yeah, temporary guardianships are treated differently than a permanent guardianship. There was the thing about, which we'll talk about in a second, about visiting judges, roles for justice partners, another thing we'll talk about in a second outside of this, the restyle. There was a removal of protective orders non-domestic. You can kind of see it. The issue was in family cases. There is a protective order. I gotta find it. Family, other family, protective orders here. In family, other family, you'll notice that they aren't shown to the general public. The cases exist, nor that there are any documents there. There was a protective order, and it was called protective orders non-domestic up in civil, other civil, that did show cases and documents. And the questions were, what's the difference between these two protective orders? And the answer, after the committee did research, is they're the same thing. And like the example is that if I go beat up Bob and Bob takes a protective order out on me, that's not done, that's still done through the family code, even though there's no familial relation between the two of us. And so then we look at, well, who's using this? And it turns out I think there's a total of 3 clerks that are actively using it, and so we're just going to remove that.
Let me make sure I understand. So they're using a motion for protective order to have, outside the family code, to have me keep John Warren from showing up at my house?
Yes.
Okay, that's not...
That's not a thing.
No, it's not a thing. You use
Right. Right here. So that we're getting rid of the other thing. telling
Okay, all
everybody
right,
to do
thank
this.
you.
That's what we're doing.
You use restraining orders for that?
Yes.
Okay.
So anyway, that's getting corrected.
Okay. I didn't even know that was there. I guess because people use it instead of restraining orders.
Yes,
Okay.
but not anymore. There was a change to add the Jones Act for Harris County. There was another change here that we've added now, fields that display in research and where they come from. And that's just, excuse me, a reflection of the reality in research. And so basically, this just delineates when people...
What's a node name?
A node name is your office or clerk or whatever you want to call it, your location.
It was up to the top. I just
Yeah, I
wanted
know,
to-
I'm sorry.
okay.
Think of this as full disclosure.
Yes.
Or where did this stuff come from?
Yeah, okay.
So
Okay.
generally speaking, when you pull a case up on research, you get a case summary page. And on it, you're going to find the style, which is the style of the case. The location, which the source is whatever the node name is in
Okay,
research.
I see what you're saying. Okay.
Case category, case type, the case file date, the judge, and the case status. And so the intent here is that Tyler asked that we fully disclose this because as they integrate, they have different clerks say, where does this come from? Or what is this?
Okay.
Or why is this?
Okay.
And so this is
Yeah.
just a reflection of what we're
Good.
showing.
Full disclosure, yeah.
And then the other thing is at some point, as OCA continues down the road of case level data, OCA will be coming to the Standards Committee to say we need to standardize this, because one of the things that we've seen is for statistical purposes, there are a grand total of 3 case statuses. Tracy, do y'all use just 3 case statuses?
Nope.
John, how about you? 3 case statuses? Richard? No? Velva, do y'all have more than 3 case statuses?
Apparently, we have more than 3.
Apparently, and so when I talk to the OCA Data Committee for statistical reporting, they say no, there are 3 case statuses, and so
In their mind.
Well, how are they importing data and turning 44 into 3?
they're not right now, but we're about to, and so. I've already told the data committee, or our data folks, that it's going to be like opening the dam for the first time in 30 years, so expect sludge, then the mud and sticks, and then it'll be clear water. But right now, yeah, so case status, I think across statewide, there's 69 unique case statuses, and the data team says no, there are only 3. And then the same thing on party types. Our data team, I had Tyler pull all the individual party types that we see on research of the top 20 counties, and there were only 375 unique case types, or not case types, sorry, party types. The very interesting thing with civil, I can understand because some of them have plaintiff and defendant and different things like that. I get it. Then in probate, there was a lot of terms that even I didn't recognize, and when I talked to our probate clerk, she was like, yeah, these are old misogynistic terms, and we should probably stop using them, and this, that, and the other thing. So there may be more standardization as we get into case level data, but right now this is just the reflection of what research is showing and where it's getting that data from when things are integrated. Permissions we talked about, and there were some changes in juvenile on the up in the filing side of things of subsequent filing types. Talking with our friends in Hidalgo County, they asked if we could add some stuff under juvenile, and we did that for them. I can't remember which of these they added a couple. Exhibits, sealing of juvenile records. We talked about that, and deferred prosecution agreements. So we've added that, and those were the changes.
Okay, so having gone through all of that, other than I think we pretty much reviewed all of it, right? All
Yep.
the
Yes.
things you had, I had it down. So, any more discussion about any of the proposed changes?
Okay, I'm gonna throw a stone in the water.
Go ahead.
So on this goes back to that justice, I'm not gonna bring up my other issue, but how, I mean, maybe this is not the time, Bob, but how are people gonna confirm that somebody's with pretrial or with the bond when they sign up? Is that something that's gonna be worked out on the back end?
That's something that can be worked out locally. Because of the different organizational, no, that's because of the different organizational structures. You're gonna have, you will have different paths that can travel.
Okay, so on the back end.
Welcome to Texas.
Yeah, okay, work that on the back end. So, okay.
Are you entertaining motions?
Yeah, at this point we will.
I would move that we adopt the revised technology standards as amended today.
Second.
Okay, we have a motion and a second. Any further discussion? Okay, all in favor, say aye. 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 Any opposed? With that, the motion passes, and congratulations to the Standards Committee on work well done on the roles and the other amendments that you have offered. So those...
And apologies, the work is not over.
Yeah, no, we have opened a can of worms, and now we have to address kind of some bigger issues now that we're moving into really the adoption wholesale of all of this in terms of having a research product. We're going to have to address this whole self-designating confidentiality and what is confidentiality and what terms should we use and that sort of thing. So we will have to kind of come up with standards with you kind of getting a group together. Are there people that want to work on those issues? And if I was a county clerk, I would want to be involved.
We need to set up a I don't even want to call it a subcommittee, but a committee.
A working committee, I agree.
On this whole issue of confidentiality.
Yep.
Because it goes way beyond standards, and depending on where we end up, the conclusion may be to drive us deeper into local practices and local system configuration than we have ever been. Because we've tried to stay that balance, that relationship between the needs of an overall system versus the need for local configuration and adaptation to local needs. So it's going to be an interesting set of discussions because it will certainly be more than one.
Oh, yeah. Okay, who wants to be on that committee?
John said yes.
We're so unique.
Oh, yeah, you definitely. So Tracy, John, Justice Doss.
Justice Doss.
Well,
David.
Anybody online want to chime in or through chat? Let us know if you want to be on this committee that's going to be addressing kind of the wholesale confidentiality issues that are coming to bear on Research Texas and basically on our e-filing system.
I think we need a trial judge.
Yes, Your Honor. This is Patty Henry. I put in my name, and Trina Gilliland would be a good clerk for that as well.
Okay, do we have some
volunteering her
trial judges? Current trial judges.
Okay,
We may
what
need
those
to.
guys run into are far different than.
Yeah, and we may need to go outside of that, and we probably need somebody from Bexar County, just because that likewise is a unique system. So
we may have to recruit.
Yeah.
We put a judge. I saw Mark Thunder.
Yeah, Mark definitely. If he tries to escape from this duty, I'm sorry. That's he's already assumed to be involved in this. But in terms of a trial judge,
I put in my confession to be on it in the chat.
Yeah.
Okay. Yeah. Blake has to be on it.
You can't hide in the computer screen.
Yeah. Judge. So are you making a list of
Yeah, I've
everyone
got a
on there?
list.
Okay. And we may end up with some subgroups as well, but yes, I think we need to file. Who did?
Laura.
Oh, perfect. And I think we may have to recruit a trial judge, so we ought to think about that and see what we can.
Should that trial judge
do.
be a family court judge, or is there any other category?
You know, it'd be nice to have one that's broad, that
General
hears,
jurisdiction.
that has general jurisdiction, that hears everything.
Needs to hear criminal cases too.
Yeah, exactly. So they would have knowledge on that as well. So that's why I think a general jurisdiction judge might be good. And we can kind of think about that. Okay, so we have 15 minutes for the remainder of our stuff. Do we want to go ahead and have Tyler's update, or what else do we have going here?
So we've got a lot going on, so
Yeah.
Bob, if you're okay, I can give an update on the rest of the
Yes,
Standards
please.
Committee stuff.
Yeah.
With visiting judge access, technically, the last meeting was, we should also be sure that the presiding judges are in the loop and are okay with implementing the way we've got visiting judge access intended to be implemented. They asked that that we hold our conversation with them until after session, because there's apparently a visiting judge bill going through.
There is? What's that one?
I don't know, but they wanted to hold on something for it, and we're fine with that.
Okay.
The other thing, two quick things that the Standards Committee wants to be everybody aware of, and I do think there will need to be work sessions on both of these topics. The first one is bulk data. You'll recall in 2013-14, when we were hurriedly switching e-filing from Nick USA over to Tyler, we said we need to focus on e-filing and we'll deal with bulk data and document access later on. We've dealt with document access. That's moving. We're starting to get people thumping at the door at Tyler, people thumping at the door on counties about when are we going to take up bulk data as well. So on the bulk data side, Tyler's hearing from data aggregators, people wanting to do background checks, things like that. They're hearing from people like, does Thompson, Steve, does TR have a matter management product?
I know that they have talked to Tyler about gaining access to the documents and
Research. Yeah. And so it's people who want access to the documents and research, people who want hearing data. There are matter management systems like Clio, InfoTrack, those guys that are like, we could really integrate in with document access into our practice management systems as well. And then I know that there are other document aggregators that right now they just want in, and those APIs exist today, and there's technical mechanisms to make that all happen, but at our direction right now in the state of Texas, those are all turned off. And so a lot of those people know that they exist and that they're turned off and want to know, can we turn them on? With that, the initial discussion then from the committee was, well, we need to figure out what exactly do these groups want, and so we may need to set up session times with a smaller group and to talk to those other groups to see what exactly they're wanting and what their use cases are, and then as well as looking at other states and what other states are doing, especially those that have these pipelines turned on. How are they managing that, and what does that look like there? So that's bulk data. So I think the Standards Committee just wants the full committee to know that
I think there needs to be a separate group set up for the bulk data for sure.
Exactly.
Because you know what, there's going to be, Clio and those guys are using this to make money.
Sure.
So what kind of revenue stream are they looking at here, and that sort of thing, right?
Agreed.
Well, and there's also tremendous potential impact on local counties.
Yeah, no, I agree.
Servers, bandwidth, access, all kinds of issues for
Yeah.
the
so-
local folks.
But it's for the local jurisdiction to make that decision. That's nobody else.
Right. I don't think there would be a necessarily mandate to turn pipes on. And Evan, do you know if those pipes can be turned on node by node, or is it global?
I have to double check on it, but I imagine it's node by node.
Right. So if that's the case, then counties would have the option. But then other discussions that the committee slowly got
The state
in.
of Texas will let you have that option. They see a revenue stream.
Well, but I mean, right now, there is no authority or pipeline for the state to get any revenue off of
Okay.
this.
All right.
There is for counties.
Yeah.
And so the counties
I
can
mean, I'm just
determine what that is. If we turn it on and those APIs come on, then there's going to have to be conversations between OCA and Tyler, because I'm willing to bet Tyler is not going to turn APIs on because, like John said, at the county level, there's resources and bandwidth that's needed, but Tyler's in the same boat. They're also going to need resources and bandwidth to be able to run it too.
Yeah.
So you can imagine there's a lot of discussions, a lot of various points, and a lot of things which the standards committee was like,
Yeah.
we probably need a group to look at just this.
Well, then we also wanted to talk to other states.
I think
that
that's
are-
important
are
that other
already
states,
doing
yeah.
this, as well as Blake suggested, and I think he's absolutely right, to talk to the data aggregator, the people that are getting the data now. I mean, appellate courts have had a long-standing relationship with some of these folks because they've been giving them their appellate records.
Westlaw and stuff. Yeah.
So there's
Yeah.
probably a lot to be learned from them as well. What are their expectations? What are their requirements? All of that sort of thing. So
And this differs from Research Texas in that Research Texas is just a stream of information. In theory, I could watch everything that was coming down the pipeline if I wanted to, if I signed up for Research Texas.
You as a human have to go and look for stuff.
Yeah.
Okay, that's the difference.
And what they want is an automated pipeline to where their computer system can say, I want to look at these 100 attorneys, give it to me in quick succession.
And I guess my thought would be then, to me, there's an interplay between those two things. And if I can get the data in the aggregate, then why do I need Research Texas?
That's true. You as a human wouldn't, but then now your aggregator is pulling from that same system.
Well, and you're going to have a thing like, Thompson Knight, Westlaw, whatever. Lexis. So what they do then, they'll have all kinds of additional information pretty easily. They'll use their AI. They'll create new products with it. They'll create a much jazzier, no offense to you, thing integrated into their Westlaw system for all those Westlaw users. And then this will be the new product that I can just see them
You see the dollar signs in
creating. I
everybody's
see
eyes.
the dollar signs big time on all this stuff, particularly on lawyers and tracking them and all that sort of thing. Whew.
Well, it's a cost savings to them too, because they
Yeah.
employ a lot of people now who
Yeah.
don't get documents.
That's right.
So.
Yep.
So we need a group for that. And
Okay.
I was going to say there's a long time ago we were thinking about tags and markers before AI kind of came into the prevalent use now, and the ability to predict or have predictive outcomes of cases at different stages with different judges, and that predictability could lead to efficiency in the court system if it causes cases to settle way before they ever get to court hearings.
They already have that.
There are two subscription services that already do that.
Yeah, they do have it. They do have it. They do have it now, but only in federal cases, not in state cases.
Yep. So do we want to identify a group for that, or?
Yeah, let's get a bulk data group identified. I mean, the problem is that the county clerks also have a huge sort of stake in this in terms of funding and money and that sort of thing. So they are, in addition to all the work.
Well, does, right? Because you told me
Correct.
clerks don't get the money.
Correct, the general fund goes.
Yeah.
And that's an issue as well. You can't say, well, the clerks are going to get X because we've set up this fee. When it gets to the county,
it goes to the general
the
fund.
commissioners may have a completely different idea about where that money should be spent.
Yeah.
Absolutely.
Yeah. But okay. All right. So any volunteers? Oh, go ahead.
So the
I was just saying that the commissioners usually do have a different outlook approach.
I didn't understand
Say that
your
again,
comment.
Judge Woolley?
You're just saying that you had made a statement saying commissioners may have a different idea where they might spend, you said they usually do.
They usually do have a different idea.
That's incorrect. They always do. Heather Marks wants to be on that committee. I'll be on that committee. I also need Richard Ballard on that committee also, since it's going to be, we need more IT.
I think,
It's gonna impact
I already
counties.
told Casey.
Technology.
I already told Casey. I was gonna do it.
Casey, I can do that one as well. This is Jennifer Williams.
Okay.
Oh,
Sure
perfect.
thing. I got you.
Okay, and Tracy, John,
Yep.
Richard, Jennifer, Tracy,
Heather Marks.
Heather Marks.
Heather Marks.
Blake. Blake, did you do something to make Bob mad? Is that what this is?
That's like spending time with things.
It's too late. Just now.
So I'm wondering if we do, no, if you want somebody else, Blake, but we do need somebody from either Blake or Justice
Michael.
Doss, just to find out what, there's already, you're selling opinions and things like that. So there's some, kind of as a resource to help us understand who.
And then the last standards item is just more of and this is a standards whole thing, just to let the full committee know that one of the next things the standards committee was looking at was adopting minimum case management system standards. And the game plan is to have the standards group have a work session, looking at the requirements that came out of uniform case management at the trial court level, and to see if there's anything that needs to be added or updated to that, and then bring that to the full committee to adopt as minimum standards for minimum requirements for case management systems in use in the state. And then we had Tracy and her e-filing document and document access committee.
So we met and we focused on the case notices for statewide adoption, and we basically we're hoping to have it tested before this meeting, but that hasn't happened, so we're still waiting on Tyler to get that rolled out to stage so that we can test some of this for Research Texas. But currently, the way it's programmed, the system will only send notices to integrated offices, so only if you're integrated will the notices be sent out. There will be an email per event on the case, so anytime an event is uploaded or integrated from that county, that attorney will receive their notice. The notices are sent for civil and family cases, and the system will not send out notices on sealed cases. We do need to get out information to both the bar and clerks. We're planning on doing, OCA's planning on doing some webinars to the attorneys and bar associations. We can also do that for the clerks. Also have a little session at the clerks conference to talk about it. And then, of course, we're going to have we're up to 18 questions on our FAQ page that we're going to have out there on Research Texas for that. And there could be a link to that in the email notice. I think I sent that to Casey.
Okay.
You did.
So all of that has been discussed and dealt with at this committee level. We also talked about the point of service contacts right now are being kind of manipulated in such a way. These pro se filers are adding like 5,000 service contacts to serve the Supreme Court of Texas, to serve TV stations, the president, vice president, and so forth and so on. That we're hoping that we can get this committee to potentially help us out. Research Texas did show us a graph. There's about 2,000 pro se filers that have over 50 contacts, service contacts, which we still don't believe that there's ever should be a need for more than 50 service contacts by a pro se filer on a case. But we're hoping that we can get a rule or this committee to approve that pro se filers would get limited to service contacts. But
I don't see
know
how
what
we
the
could
rules are.
possibly do that.
What authority?
Yeah, what authority would we possibly have to preclude someone from accessing the courts? None.
No, they can file all they want.
Yeah, they
Yeah.
can file.
But it's on you to, if you want to serve 5,000 people, take what you filed and email it to them. Why should the e-filing system be told to email all 5,000 people on your behalf?
You just need to think, I think, of a different way than saying if you're pro se, you only get 50 or less people. I think you're going to run into, and I'll think through all of the statutory, constitutional, or other issues that might exist for doing it that way. It's one thing to do everybody and just say everybody's treated the same. It's another to say, I'm sorry, you're pro se and don't have a lawyer, so now this is what we're going to do to you. So anyway, because the way they take care of bad behavior or kind of crazy behavior before was basically through, as a litigious person or whatever, you can take processes, but there's an opportunity to be heard and whatever, you know what I mean? So
Rather than restraining somebody on the front end.
right, before you have any idea,
So the intent on the front end is that we are seeing more and more and more of where I've got appellate judges calling my office saying, we're getting notices that this thing has been e-filed and it's ex parte and they shouldn't be serving us, and I can't prevent someone from putting the judge's email address to say serve this person. I can go in and tell Tyler, do what?
You can give Tyler those email addresses and say, don't let anybody serve these email addresses.
Okay, so I can do that.
I don't know that you can.
Serve the judge. I don't know.
Well, you mean serve their personal email or something?
No.
Your work email
They,
address.
no.
I mean,
Pro se's will say, I want to serve rebecca.simmons@txcourts.gov, and if you're on the fourth court, doesn't matter, you're going to get that email. Now, you would probably be like, whatever, delete, and then have a nice day. But then there are judges that are like, why am I getting 15 notices
well, no,
from
you
this?
should ask why, and you should be annoyed and everything else. I just don't think that there is a way that you can. We would just need to be much more careful, I think, about who you're going to limit.
I think it's a valid point that there could be other ways of achieving
Yes.
what you want to do.
Right.
Maybe, like, domain blocking, if the judges, appellate court judges don't want to get it, and that's what they want, and that's what they want you to do, then you could do that.
Absolutely.
There's got to be some rule of access for using the e-system to begin with, but if you're using it to abuse the system, you can lose your access.
Well, that's what happens. So that can happen today. And what we do is we say, Tyler, we have this email at crazyprose.gmail.com, and they say, yep, they've been deactivated. Then 2 days later, Casey, I'm still getting these notifications because now it's coming from crazyprose2@gmail.com. And so they just go and keep going and going and going. So
We have, right now, from what Tyler sent us, there's 13 filers that have serviced over 1,000 parties.
But why would you ever need to serve a judge?
This is Patty Henry. I have an explanation. I have an example, if you would like to hear it.
Okay.
go.
Okay, we have a pro se filer who added 1,800 service contacts to all of his filings, and he did it to the DOJ, the AG, Supreme Court Justice. He did it to everyone. And no one was asking, of course, everybody was complaining, we don't want this information, but we weren't asking for that. What we were asking for is the Attorney General was the prosecutor on that case, and they said, please, is there a way that when we respond to and file an answer in e-file that we don't have to check, we don't have to send our answer to 1,800 service contacts. Because right now, we have to manually go in and uncheck each service contact to get rid of those 1,800. Is there a way where we could have an option to choose delete all service contacts, add only these certain service contacts? That's what they were asking.
Yeah, and we have those instructions on, there's a unselect all button that you can just do all 1,800 at once.
But can I go back to my question? Is there a reason to serve a judge through the e-file system?
It could, I mean, if you're suing that judge, maybe you're suing him because you were in a car wreck with him. I don't know. I mean, there could be, and what I hate to do is...
Why would you be serving him at work?
Because that may be the only address I have. I don't have his home address, but I know I can serve him there.
That's confidential information.
If I'm filing some documents
exactly.
with the court, I have to physically show that the judge actually received and considered what I'm requesting. And if the judge doesn't do that, I can't complain on appeal that the judge personally got it. So I think of some motions for new trial.
And don't we typically with original proceedings serve the judge too, the district judge?
A request for 459.
Well, I mean, it's true they are designated as a party.
Yeah.
So if they filed a dancer or something, then they would have their service contact address added to it. They could add it to the case at that point.
Yeah.
Is that who you serve? I guess I haven't really thought about it. Do you serve the judge? With
Well,
the
if
names?
I have to always check every time, but I mean, I think
I think you do.
Yeah, I think you've served to the judge. Some of them you hand deliver too.
Jamie, do you have a comment?
Yeah.
I just want to state that I think the obvious, but if we limit it to 50, that still isn't going to eliminate this problem because they could choose 50 judges or the Department of Justice or the governor or whoever within that 50. So we still could have the problem. We wouldn't have it at Patty's level that she's talking about with 800 service contacts. But once if we were to go the route of limiting it, we just can't say, okay, you can only have 50 and they can't be within this list of people. So I just wanted to remind that this may stop it from being massively widespread. It can't stop the overall problem that we're trying to stop.
Don't you solve it though through, I don't think you can name 50 or whatever and do it to pro se. I could be a lawyer, right? I'm filing a case and you know what? I'm involved with oil and gas and I want to know who all the heirs are. You bet. I've got more than 50 people. And it could be a judge too. And I mean, it just, so I'm pro se, I got 50 and who decides? You? The clerk? I don't understand how we could possibly get by with that. What I do think is the model that's used is the litigious litigator. There is a model there. That's what they do with someone who is abusive. And so I think you have to take something like that where there is a determination not based on just the number of people you're serving or the fact that you're pro se. I don't know. I just think I'm uncomfortable.
Where the rub came on this is the judges who were all getting this saying, why am I getting all this?
Yeah.
And it was coming down on the clerk.
Right.
Nothing I can do about it. Is another technological way of doing it is that I've always had hope for this, is that if I'm receiving it, rather than call the clerk and say, do I have to get this? Some way for me to uncheck myself for all future responses. So then I'm responsible for my own. I uncheck it. I'm taking the risk.
We talked about that at the last meeting, I think, didn't we? About a mechanism.
Okay, so let's go back. We're just serving motions. Is that what we're talking about that you're serving?
It's whenever you e-file something, you can go in and say, I want you to serve these people.
Right, so we're not talking about service of process.
Could I opt out of service?
Yeah.
No,
you're not talking about service of process.
Just that the document was filed.
So anyway, could you just, okay, so they're not really defendants or not parties to a case or anything else.
Right.
Correct.
It's like you take your filing that you would give an over-the-counter, and now you're going to make copies and mail it to everybody.
Yeah. No, I can understand.
In the case that Patty is talking about, I actually had to request through Tyler to remove all OAG staff, everybody off, and then they kept adding them, so then I'd send them in another ticket.
Yeah.
And that's part of the problem is because, yes, even if you opt out, that doesn't stop the person from their next filing to say,
At least 4 or 5 times.
She's having to manually tell them and they do it. I'm saying,
Yeah.
if I can have an option to do it, and maybe an option to say, for this case, I'm removing myself from all notice and service.
Can you not come in and then just get a finding of litigious filers and then just cut all that off?
Well, the
Or-
vexatious litigant route
Yeah.
is that you have to have lost 5 cases within the last year.
And
So
you have to file
that's how you get on that list.
Well, how about, yeah, but create another kind of
Something like that.
process to do something like that. I think a process,
Spam litigant.
Well,
Yeah,
and
spam
that's-
litigant
and
or something.
The vexatious litigant is by statute as well, so
Yeah.
it's not a
Yeah.
it's a statute.
Yeah, I thought we talked about this a couple of months ago.
We did
where
talk
we talked
about
about physically removing yourself from the services that attorneys
that's
do. in a-
right.
Opt-out provisions that I think
Yeah, I mean, that's
left
one
on
way
the
to get rid
table,
of it.
but it should be available, because especially since we're semi-automating service, and there's a propensity for people to either default to select all when they're serving pleadings, or these abusers to overserve intentionally. And an opt-out provision would help, especially
Can you do an
if it
opt-out
makes
permanently so that they can't just use that email address?
an opt-out that would gray out the name of that person in that case number for the future until and unless they were to go into the system and opt in for some reason, But that would solve the problem.
There's probably ways to skin the cat too,
Yeah.
which I think would be worthwhile to have a discussion.
Yeah, we just need, we need to move
But I
on.
love as well, it's gotten, I was just telling Velda, it's finally in my 5th year of retirement, finally starting to see them drop off, but in the past years, I'm getting notice for all these cases for
Yeah,
5 years ago. I'd love to, and what I do is call a lawyer that I think is, they're working for county attorneys. I was saying, I've got this, did you get it? Make certain of that. But I'd love it to be able to check something and saying, I'm not involved in this case. I'm never going to be. It has nothing to do with me. Check out. I never received any other notice for it.
And can't be added back in.
Right.
And I'm fine not to get it.
Right.
Somebody in the chat volunteered to help out with it.
Yeah. So we can take that back to this committee and work
Yeah.
on those details and try to work
Okay.
that out with Tyler.
Yeah.
The other thing was gaming the system. I'm guessing some attorneys deliberately e-file only and then don't e-file and serve. And then when they FedEx the document to the attorney much later, then they get what they need.
So the example of this, Sion gave us the example of this, and it was a case to where the attorney, they're on a time deadline, right? Like, if I file something, the attorney has like 10 days to respond or whatever.
Okay.
So when I e-file it, I pick e-file only. I'm not going to serve it on opposing counsel. I'm just going to hit e-file only. And then I'm going to turn around and lazily take this paper copy of my filing and hand it to my paralegal and say, can you FedEx this over to opposing counsel, and you can use the slowest possible route cheapest route on FedEx, and then it shows up much closer to the response deadline. And then I, as the attorney, said, well, Judge, I served opposing counsel. Here's the FedEx receipt. It went to them, and it just happened to get there with 2 days remaining, when I could have hit e-file and serve and given it to the opposing counsel right then.
I don't know why anybody would do that legitimately.
Apparently,
They have.
in stats, when we heard of this, we asked Tyler, can you give us the number of times on a subsequent filing and so by default the system is set to e-file and serve. You have to proactively go and click on I want e-file only, and it happens as significantly. It was
2.6 million filing counts. 3.9 was e-file and serve, and 2.6 mil was e-file only.
And the mailbox rule used to cover how to respond.
Why do we let?
Yeah.
Why do we do that? Why do we allow it?
I don't know. Well, supposedly the e-file only option was out there is if you had already served the parties, but you just needed to file it with the clerk. But I don't know why we would even still have that option, just
You
make
would,
it.
you would have it for initial filings if it's,
Correct.
I need traditional service on an initial filing, but on subsequent,
Subsequent, we shouldn't allow.
Yeah, I wonder if it just gets back to when it was optional or was it mandatory?
yes.
Does it, don't the e-filing rules say that if you e-file, you have to e-serve if their email
I thought they had to e-serve.
The system is-
I'm looking at it
system is
right
set up
now.
Where you could choose not to do that.
Yeah, no, you
The
can
rules say
choose,
You have to, so that whoever got FedEx the stuff could.
The 2.6 million.
Yeah.
That happened 2.6 million times over the last, what was it, 6 months or a year that we looked at?
Yeah, so documents filed electronically under Rule 21 must be served electronically through the electronic filing manager. If
Yeah.
the email address of the party or attorney to be served is on file with the
Right.
electronic filing manager.
And it-
yeah, you're
So-
supposed to, in the
So we
civil
tell the attorneys
cases,
just to go to their judge and say, hey, you didn't serve me properly?
well, then, yeah, you can say, you know what, the notice is not good. I mean, I'm supposed to have this much notice or whatever. I mean, I just, that's why I'm kind of going,
That works when you have time left, but when you are on a type of deadline that then restarts the clock, you can say all you want, I wasn't served properly, but if that deadline hits, guess what? The clock gets restarted. So it happens fairly regularly. It used to happen all the time with executions.
it does happen in the criminal side. I don't think it happens near as much. I don't think what you're talking about happens as much in the civil side.
So Rule 21A
Yeah.
covers it, though.
Yeah, exactly.
A document filed electronically under Rule 21 must be served electronically.
Thank you, because I was sitting here going out of my mind thinking, why are you Federal Expressing? You can't do that. Okay, thank you. I was trying to look up 21A right now.
Yeah.
So if that's the case, should we go back to the subcommittee and make sure everybody's comfortable with turning that option off? Because we could have a direction to Tyler saying, on subsequent filings, we need to make it
really
so
not a way
that
to opt
you
out, at least
can't
under the
opt
rule.
out.
Subsequent filings opt
Yeah,
out
other than
of,
the
I don't know what you're
original
saying.
law.
So that if you're doing a
Original
subsequent
petition.
filing, you have to e-file and serve it. You
Right.
can't say
You
just
can't choose,
e-file
you
it.
can't manually say e-file only.
I'm trying to think of why you would just want to file something.
Because I want to game the system.
But it doesn't gain you anything on the civil side, really. Why does it gain you anything? Because the other side doesn't have, has lack of notice.
Opponent to respond.
Huh?
I mean, it's terrible. You're shortening the time for the opponent to respond.
Yeah.
Well,
Like,
if you
let's
were
say summary
required to
judgment.
e-serve, right? I mean, so you're going to e-serve them at some point in time, and it's going to,
Apparently, some people don't. That's what I would just.
well, then they don't even have notice of whatever it is that you filed. So at some point when you serve them by email, your deadline will start to run. Your service is effective when I receive it, not when you file it with the clerk. I'm thinking of discovery and all those other
Actual
things.
service
That's
is
just,
complete at the time you deposit it in the mail or you deposit it.
well, when it's uploaded, when you upload it, but what I'm saying is, in terms of your deadline to respond to discovery and everything else, it's, you know, it's when you get the email, when you're served, you know, with it, right? So I don't understand. I'm trying to figure, and you don't file it with the clerk anyway, so none of this matters for purposes of discovery. I'm just trying to think.
Summary judgment motion would be an example.
Yeah.
So
So.
if on my reply to your response, but I want you to see it before the hearing.
Yeah, 3 days before the hearing, you
Yeah.
send it on a Friday.
Okay, and so you come before the judge and you say,
In the mailbox, you've met the mailbox rule,
And-
but they're not going to get it.
well, I know, and so you go before the judge and go, by the way, that he never emailed me. Counsel, did you email them? No. What?
Yeah.
I
It's
mean,
just that you have to know, you're going to have,
It would
a lot of
nev-
people don't know the rules, I think, and I would probably look it up and tell the judge, no, they had to send it to me by e-service, and they didn't, so. but-
Anyway, I just don't know when this.
What about the filing of confidential or sealed documents?
Yeah, it's sealed documents or something like that. I mean, I just don't know. I don't know. Yeah, you're not going to serve the sealed documents on somebody else. You may give it to the court.
Yep.
Yeah. Anyway, I don't know at this point in time, I mean, if I feel, I think it's worth discussing. I don't know that I feel comfortable that, I guess I have too much trust in lawyers. I just,
Yeah, I think we ought to think about it. I think it's worth talking about.
Yeah,
Whether that's
yeah.
just gonna be-
No, I agree. I agree.
I mean, what happens as a matter of, man, this sounds terrible. What if we just shut it off for a period of time as a test?
Yeah,
Maybe
see what people say.
Yeah.
See who
See
screams.
who screams.
I mean, 21A says you will file.
I promise, and lawyers know this, right? The lawyers do know this. They
I've
do
never
not.
had this happen.
Exactly. I mean, they
I'm
don't.
shocked that, that 2.6 million filings. I'm
Or you
shocked.
follow them,
Yeah, I mean, I don't know if they're sending in their vacation letter and they've already sent a copy to opposing counsel. You know, what I can see is that they've already sent or communicated or done something to the opposing counsel and now they're uploading to the court or something, you know? I don't know.
How many of these could be proposed orders?
Yeah,
Do we have any data breakdown
I
on
don't
what they are?
know.
but even proposed.
Again, why would you not serve that on
Yeah,
opposing counsel?
Well, the rule is that you have to serve whatever you're, you know what I mean?
You would, I guess, in theory, but if it's already signed by everybody, everybody's signed off, I don't know. I mean, I'm just curious what they are.
Yeah. We can dig a little deeper. We can get more data for this
Right.
committee to look at too.
Yeah, I think just get more data, because I'm so confused about why people are filing so much.
We
and
maybe
what
out of the
that means.
2.6 million, get Tyler to tell us how, what are they filing?
Categories, yeah, what are the case
categories
types
that
or
they're
whatever.
filing And
Yeah.
what case types.
Yeah, that'd be great.
Yeah.
So I'm just confused.
Okay.
Who are they?
And
Well, is it,
They're the pro ses with the thousands of, it's the people pro ses that have thousands of,
who are these firms?
yeah.
Okay, and then the last thing is the committee is committed to looking at the e-filing issue list that was started back in the clerks way back when. And so we're looking at each one of those issues to see if they're still needed and what Tyler should work on as far as the EFM goes. And then, of course, I don't know if you want this committee to come up with a date that we're going to start the e-notices, but once Tyler gets it rolled out and we start testing the functionality, we're thinking June 2nd would have been a good date to start it, but since
That's not going to happen.
That's not going to happen since it hasn't rolled out yet. So as soon as it gets rolled out and we get it tested and we get the webinar set up, maybe July at this point, but
Could we merge this conversation with the prior one where we were talking about the opt-out provisions? Because originally we had talked about this in subcommittee. And would we be able to roll it out with that functionality, solve two birds with one stone?
When you say opt-out, do you mean opt-out of case notices?
As for a particular case that we're no longer active on, rather than clog the courts with motions to withdraw or the clerk's time with calling them, stuff like that, as well as cases, particularly in family law, that are post-judgment cases where there are thousands filed every year. And we're not active attorneys, but we're getting these by people just checking all.
That may be part of the discussion actually with earlier about these people who file and serve the wrong people, multiple things to them.
Here's one other thing for Tracy, for your group to look at when you're looking at this data. Because 21A anticipates that to be the method of process if the recipient has an email registered on file to
Right.
receive service. If they don't, then you still follow the traditional process of mailing,
That's right.
et cetera, which means there may be a need for a file-only.
However, today, if you're an attorney with a bar number, you have an address on file.
Better have an address.
Yeah, but you're going to be serving lots of other people that don't have attorneys, right? You're going to have, there's a million cases where I've sued someone who doesn't retain an attorney, right? And so they're going to get mail. So now that makes me understand better. If you don't have an email address, then you file with the court, and then you're responsible for Federal Expressing or doing whatever you're going to do to the pro se defendant. That makes more sense. Okay.
On the subject of opting out, Casey and Justice Simmons, I sent an email
after our February meeting, stating that we had agreed that Tyler will create an FAQ regarding how to be removed from the e-service list for a case. And Tyler will add a message in e-service emails with a link to this FAQ.
Yes.
Yes, I think that's on
But we need the FAQ.
service messages. We need to check to see. I think we did that. We'll double check. And that's for like how to remove yourself, how to get removed from the e-service list. Because there is a way.
Yep.
It's either enter a ticket with Tyler and tell them get me off, or contact the attorney and the attorney can knock you off.
What else? These e-notices will be going out from a different domain than the e-filing notices, so that they can tell the difference. They are coming from a no reply at researchtext.com instead of textcourts.gov.
Okay.
So they are coming out from a different domain. But if you're good with the group, once we have it all figured out, rolled out, and all that good stuff and tested, then we can come up with a date.
Yeah, that'd be great.
To roll out.
Yeah. All right, great work, Tracy, with you and your group, and we have some further refinement to do. Okay.
So, Judge, I was going to suggest, and it's completely up to you and the committee, that I do have Evan's presentation, and if we are running behind, I'm happy to circulate that to everybody and ask questions. I've looked at it, it's the standard. Here's the review, here's where we are, here are the return for corrections kind of data, and where we are on research.
So you would send around the PowerPoint with the counties that are covered, who's integrated, who's not.
Yes.
And the return for corrections kind of data.
The data that we normally have. I'll point out that the highlights of it for the research integrations, we're working with Harris County District to get their integration up and running. We're working with Net Data to get Nacogdoches County up and running. They've kind of fallen behind in their coding of things. We're working with EDOC, which does McLennan County and Coryell County. They're getting closer and closer every day. I'm included on the traffic with that. And then Angelina County is in the middle of procuring a new case management system because they're on a version that is so old it can't possibly integrate.
Okay.
And then Orange County, that's in the middle of a conversion, they should be integrated here fairly quickly. Yeah, at the end of July. So we have gotten integrations not only from Odyssey customers or EJ customers, but LGS did their first customer in Ellis County, and working with them, they did commit to, hey, we can run the schedule for the rest of our customers and get them all on by November the 1st. So that's good. iDocket right now is visiting with their teams internally. They've also achieved integration with their first county, and so they're considering the same thing to where I can tell Tyler, you take these counties that are iDocket counties, don't worry about them. They'll handle the scheduling of it and get them in by November.
Okay.
Tyler right now is working on phase 3, mainly Tyler customers, getting them integrated with research, and so those are now starting to come online in anticipation of that November 1 date. And then, like Tracy said, OCA will be at the clerks conference coming up in a few weeks. And one of the topics we'll be talking about to the clerks is research integration and what this means. Because we still have a lot of questions from clerks about, oh, I don't want CPS cases to be out there. I agree, they're not available to the general public. This is it. Well, what about these cases? Well, no. Well, I can see this. Well, that's because you're logged in as the clerk. You're supposed to be able to see that. So we continue to kind of troubleshoot those little things as they come up. But generally speaking, I think you'll see in the slide deck it was 30 some odd plus % of clerks' offices. But you have to remember that there are 139 of clerks' offices with populations of less than 60K. So that's more than half, or a large chunk. But population-wise, most of the larger counties or all the larger counties other than Harris District in the moment and McLennan, they're integrated. And 60,000 up, I think that's like 6 more offices that we're still working on, but then everybody else is already integrated.
Okay, well then that sounds like progress is getting made. What about Tarrant County? Did they get done?
Yep, they're done.
That's what I thought. Okay. All right. Let me just poll the crowd that is here and on the phone. We can have a full presentation by Tyler, and thank you for sitting through this. Or we can go ahead and just take the PowerPoints with the important information from Tyler, in case he would circulate that. Do I hear a motion? Do we want to adjourn? Do we want to press forward with Tyler?
I move that we get it circulated by PowerPoint, but also note that I think Laura had a question.
Laura. She have a question in the chat?
I thought so, something Casey.
Oh, she was sending it to me directly.
Oh, okay.
Anyway, regardless,
She's not happy.
yeah, my
Happy
motion is
birthday.
that we just do it by PowerPoint as suggested.
Okay, a motion's been made just to proceed and get the report from Tyler this meeting. I have a second as well. All in favor?
Aye.
Aye. Any opposed? Okay, with that, we're going to go ahead and stand adjourned, and we've got some work to be addressing here in the future. And thank you very much for coming to the meeting and for your input. And we look forward to seeing you again.